The Honorable, the Chief Justice, and the Associate Justices of the Supreme Court of the United States. Oyez, oyez, oyez. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near, for the court is now sitting. Everyone take a seat.
Ladies and gentlemen, we will be hearing oral arguments in the case of Denver Dispatch versus United States. Docket number 93-8000. Are the petitioners ready?
Are the petitioners ready? Say loudly, yes?
Yes. Are the respondents ready?
Yes.
Petitioners, you will have 30 minutes to state your arguments and respond to our questions. You may proceed with your arguments.
May it please the court, we are the petitioners representing the Denver Dispatch newspaper. We are here to ask the Supreme Court to remove the court order that forbids the Denver Dispatch to publish articles about biological warfare at the Boulder Research Laboratory.
Your Honors, thank you for your time today. I feel that discussing the right to freedom of the speech and of the press is a very serious matter. Without these rights, what exactly does American freedom add up to? Justice Hughes wrote in his majority opinion in Neer v. Minnesota in 1931 that this means that we have to let the press or anyone publish what they want, even if what they publish is bad. The government must allow the Denver Dispatch to publish what they want, as the First Amendment provides the right to. And afterwards, they can be punished if they broke a law. What right does the government have to stop us from publishing? We are within our rights, and the government cannot take them away. Does the government decide what we can or cannot do, or is it up to the law and the Constitution?
As an attorney for the Denver Dispatch, I stand before you today to argue the paper's rights to publish the remaining articles on the current biological weapons research at Boulder Rock, Colorado. Justice Douglas issued his dissenting opinion in Dennis v. United States, 1951, that free speech is the rule and not the exception. A law which prevents free speech must be based on more than fear of dislike of the ideas being expressed. To prevent free speech, there must be the likelihood of immediate injury to society if the speech were to be allowed. Therefore, it is unconstitutional for the government to restrict the right of the Denver Dispatch to publish the remaining articles.
We are the respondents, representing the United States government. We are here to ask the Supreme Court to uphold the court order that the lower court and the appeals court imposed on the Denver Dispatch newspaper. That court order forbids the newspaper to publish further articles about biological warfare research at the Boulder Research Laboratory.
Your Honors, thank you for taking the time to hear this case in which our national security is at risk. Justice Frankfurter wrote in his concurring opinion in Dennis v. U.S. 1951 that Congress is allowed to pass laws like the Smith Act which limit speech that is truly dangerous to the nation. Therefore, it is constitutional to ban the Denver Dispatch from publishing the remaining articles because speech that is truly dangerous to the nation can be limited. Now, the articles the Denver Dispatch planned to publish will release secret information about the government and military weapons that can only do harm to us as a nation. What the Dispatch plans to release gives the government the right to limit their freedom of speech because it can be a true danger to the U.S. Anything, these people knowing will only cause panic. These are the true dangers to the nation that does give the government the right to limit the Dispatch's freedom of speech, and it is therefore constitutional to ban the rest of the articles.
The government has a right to punish anyone who threatens national security, but since we are not in a declared war, is this a time to violate the First Amendment of free speech and free press by stopping the publishing of the Denver Dispatch articles?